Anything further from the defense?
Yes.
Ms. Nutley prepared to be taken in custody?
Yes, sir.
She needs to read and sign that form, and then you can take her into custody. Probably. You can come over.
This is one of the most emotional courtroom moments ever. A former teacher stands before the judge, facing sentencing for crossing the line with a 17-year-old student. The judge, clearly torn between justice and mercy, points out that the defendant only sought help after pleading guilty and never truly showed remorse for the damage she caused. She reminds the courtroom how the victim's trust, confidence, and future were shattered by someone meant to protect him. After carefully weighing every factor, punishment, rehabilitation, and the safety of others, the judge delivers a firm but fair sentence. 3 years in prison and 5 years of post-release control. Let's dive in and watch.
Well, I would agree with the last thing you said, which is I will look at this the way I need to, because Ms. Nutley, this is a very difficult decision for me. The factors I have to consider include what's the appropriate punishment, what's necessary to protect society and the public, and what rehabilitation, and do you want rehabilitation, is possible. Every factor comes into play in this case. And what I have to decide, looking at each of those factors, is what happened. What I find frustrating about this case is that I'm the one that set bond. There was no OR bond, no EMU, and the prosecutor didn't want there to be any restrictions on the bail pre-trial. And I've never seen a case with these charges without some restrictions on bail, and I never understood this case until I got the sentencing memos on Friday. Because no one ever shared any of the facts with me, or any of the damage, or anything that happened to the young man in this case. And now that I understand everything that happened, I do think that the most important factor that I need to look at is what's the proper punishment in this case. So let me say that there's several rehabilitation issues here, and I take them seriously. Dr. Bassman has sat in this witness stand, and he has testified, and he has been cross-examined by me, and in many sexual offense cases, he's providing a report. He's got a great program. So does ODRC. Same program. I am concerned about the need for rehabilitation and the desire to be rehabilitated. I don't know how sincere that is, because Ms. Nutley didn't start until after she pled guilty. And I have seen many defendants in this courtroom begin their rehabilitation, begin their treatment the day they get arrested, the day they talk to their attorney, long before it comes to sentencing. And I have a whole long track record of how they were doing, whether probation was a good idea. And in this case, I don't have that record, and I'm not sure what to do about the fact that Ms. Nutley waited until after you pled guilty. But more importantly, no one's really addressed the alcohol substance abuse issue that was in a court clinic report and in the facts. It's my understanding from the facts that I was given, it was the officer's statement, the text messages, the information that I have is that she was under the influence of alcohol, drunk. 2 bottles of wine at the Christmas party at the school on one of these days that the sexual battery occurred. And there's nothing about that I don't hear any treatment for alcohol abuse. I don't hear any acknowledgement that that is part of the problem, or any want to be rehabilitated. And I think when you look at the court clinic's recommendation that there be treatment for both sex offense and alcohol abuse, I think that makes this even harder for a person to be successful on probation. So when I look at the factors, yes, the victim in this case was 17 years old, a student at the school, being counseled and supervised by an educator who he trusted, a person in power over him, a person who was supposed to be protecting him. And it's that relationship, your power over him, that gave you access to him, that gave you the opportunity to commit this crime at the school. And that is all the factors that make this a more serious case than normally a normal situation that constitutes sexual battery, all weigh in favor of a prison term. On the other hand, recidivism is another factor I have to consider. And you haven't committed a crime, you haven't been prosecuted for anything in your life, you have not been accused of this behavior in any other way, and I am going to ignore the statements and the materials that I had that there may be other situations.
This was one of the most powerful sentencing moments caught on camera. The judge, clearly conflicted, explains that this is not an easy decision. She must balance punishment, public safety, and the possibility of rehabilitation. What frustrates her most is that the defendant only began seeking help after pleading guilty, showing little true remorse or accountability. The judge highlights the abuse of power a teacher taking advantage of a 17-year-old student who trusted her, calling it a serious betrayal. While noting the defendant's clean record, the judge makes it clear that the position of authority made this crime far more severe and deserving of real prison time. Let's dive in and watch.
Or there may be other children who didn't want to come forward. I really cannot consider that. So I am just looking at the facts of this situation. But when I look at recidivism and a low risk that you have of reoffending, I worry about the alcohol abuse again. Because if that is what was causing the behavior and the terrible judgment, is it the depression? Is it your own trauma that you've had in your life that you can get treatment for? You know how to ask for help. This is part of your training, and your job is to ask for help for your students. You know how to ask for help for yourself. But you didn't do that. And if you didn't treat your trauma, you didn't treat your depression, your substance abuse, then I do worry that there could be this could happen again. So recidivism is an issue for me. But really, this final factor that I look at is remorse. And I was so looking forward to you speaking today, because I really wanted you to tell me that you were remorseful. And I didn't want you to use those words. I don't care if you don't say the word apology. But, what I was looking for was for you to say that you acknowledge the harm that you caused this young man and pretty much ruined the rest of his high school career. I didn't see it. I didn't hear it. I don't even know if you read the reports from his family, the letters from his family. But what I learned from reading that is that your behavior destroyed his confidence in himself, his education, his college career, his scholarships for sports, his relationships. He feels guilty. He feels shame, and he's the victim. I didn't hear or see anything that you acknowledge that. Ms. Nutley, you caused him the same trauma you suffered as a child of sex abuse. You knew what this would do to him. He shut out his family, he shut out his friends. That whole period of time between, I don't know when the relationship ended, honestly, I don't know any of the details about what happened after the last day in the indictment, December of 23, but it's not until October of 24. So 10 months. I see from the materials that you wanted him to keep your secret. And you encouraged him, and you paid him money, and you gave him favors, whatever you were doing. He was keeping your secret. That's what destroyed him. Because he didn't have family, he didn't have friends, he had no one to talk to. And the way his father described the way his life changed, and didn't understand what was going on with him during that time because he didn't know anything about the sexual abuse, and you're trying to make him keep this secret. He lived with his negative feelings, he felt guilt and shame, he was traumatized. He was not letting anyone help him because he was protecting you instead of you protecting him. Before the sexual offense, he had a mom and a dad and a sister and teachers who described him as happy and goofy and athletic and loving and hardworking, and a young man who had a great life ahead of him. And all of that is gone. He's not in treatment, from what I understand, which is very sad, because that's what he needs. He did not sign with any school, so he doesn't have a lacrosse scholarship for college. He lost his spirituality, he became angry and cynical, and he distrusts people. I didn't hear any remorse for causing any of that. And that's what I was looking for. And I will say to this young man, because I just described you in a way that your family and friends and teachers described you, is that it is my hope that when this case is over.
The judge's words cut deep. She lays out the emotional and moral weight of this case with raw honesty. She acknowledges the defendant's low risk of reoffending, but says the real concern is untreated trauma, depression, and alcohol abuse, the very issues that led to this terrible judgment. What truly breaks her is the lack of remorse. The defendant never once acknowledged the pain she caused her young victim, a student who trusted her, whose entire future was derailed by her actions. The judge paints a heartbreaking picture of a once bright, athletic, and loving teen now living with shame, guilt, and isolation, all because he was protecting his abuser instead of being protected. It's one of the most powerful reflections on accountability you'll ever hear. Let's dive in and watch.
And I sentence Ms. Nutley to what I hope is a just sentence, taking all these factors in, that you will be able to see how brave you have been to come forward, and how courageous you have been to tell your story, first to your parents and then to the police. Because what you are doing is protecting other young men from being sexually abused by their teachers in many ways. Because you can show people you can be brave, and you can speak out, and you can tell the truth, and your life will get better. You don't feel that way today, I'm sure, but hopefully in a few years, in a short time, you'll be able to seek the help and the treatment that you need, and that you'll be proud of yourself for doing this. So back to the sentencing factors, I left off at remorse, which I do not find genuine remorse in this case. And there's another factor I wanted to address that the detective put in his statement, and the prosecutor, Ms. Dieters, mentioned about what happened in this case now that we know all the facts. What are they thinking about what's the sentence going to be? Because I agree with Ms. Dieters. If they think they're just going to get a slap on the wrist, then why not? And I do consider that to an extent. And putting this all together and thinking this through, and I have been giving this a lot of thought, because if anybody knows me, they know that sentencing is the hardest thing I do on this bench. First, I want to address the family has asked for the maximum prison term, which is 5 years on count 1, 5 years on count 5, to be served consecutively. I do find I could make this consecutive findings, which means the possible maximum sentence is 10 years. And I considered that. And no one addressed the consecutive findings in any of their materials. The state's not asking for consecutive, but I looked it up and I thought about it and I've considered it. But when I balance everything, I do not think a 10-year prison term is the just term here. And you don't have to agree with me, but I just want you to know I did consider it seriously. And I did think about the officers, 18 months, because I thought that was an interesting number, and I appreciate today that you've adjusted that number. And I have looked at other cases. My staff looked up other cases. I think the median average was, the median and the average was 3 years on cases like this. And I did consider probation. Ms. Nutley, I think, talked to lawyers who practice in this courthouse. I love probation. I have a 90% success rate. Of the 90% of the people I've put on probation in the last 4 years have not gone to prison. I find that to be a success. But in this situation, I believe that the proper sentence is 3 years in prison on count 1, 3 years on count 5 to be served at the same time, for an aggregate sentence of 3 years in prison. The parole board must put you on a period of post-release control of 5 years after you get out of prison. And the sentences, and you are also subject to Tier 3 sex offender reporting restrictions, which I'll go over in just a moment. I will not require that you pay any fines, but you are required to pay court costs and a $30 reparations fee. I will put in my sentencing entry, Ms. Nutley. I do take this very seriously, that there were comments that you had suicidal thoughts at one point. You went to the Lindner Center. There was comments from something I read, worried that you might have suicidal ideations yourself. So I will put in the sentencing entry that ODRC will be required to evaluate you and the jail, if you'll start at the jail, for a suicide ideation and provide all precautions necessary at the time that you're taken into custody. I want you to know, Ms. Nutley, I thought about this very seriously, and I do hope that you have hope and don't feel that this is the end of your life and career and relationship with your family, because this is a punishment and it will end, and you will come home and you will get treatment and you will have access to substance abuse and sexual offense treatment in prison and on post-release control.
The judge delivers her final words with a mix of firmness and compassion, acknowledging the victim's bravery for coming forward and protecting others from future abuse. She tells him that even though the pain feels unbearable now, healing and pride will come with time. Then, turning back to the sentencing, the judge explains that she weighed every factor carefully, from the family's plea for the maximum 10 years to the defense's arguments for leniency. After deeply considering remorse, trauma, and justice, she ultimately decides on a 3-year prison sentence, followed by 5 years of post-release supervision and classification as a Tier 3 sex offender. The judge stresses that this isn't meant to destroy the defendant's life, but to hold her accountable, ensure treatment, and protect others. Her tone closes with a solemn balance of justice and humanity. Let's dive in and watch.
The post-release control period, which I said is a mandatory 5 years. As part of that, the ODRC can add additional conditions. In addition, you are not allowed to leave the state when you're on post-release control, unless you have permission from your parole officer. The parole board can also impose any other post-release restrictions, sanctions, or financial sanctions that they choose. And if you are released from prison and placed on post-release control and you violate one of those conditions, they can send you back to prison for up to 9 months. And if you have multiple violations, they can send you back to prison for up to 50% of your stated prison term. If you commit a new felony while you're on post-release control, the parole board can send you back to prison for the remaining post-release control period, or 12 months, whichever is greater. And if you're sentenced on that new felony to prison, you'd have to finish your prison term on this case before beginning a prison term on any new case. Days of credit, you are able to earn those while you're in prison. You can earn up to 15% off your sentence. Next, I would like to go over the explanation of the duties of a register as a sex offender or a child victim offender. First of all, Ms. Nutley, you'll be a Tier 3 sex offender with notification requirements under the statute. I did not have a signed version of this form. Do you have a signed version for Ms. Nutley? Otherwise, she will need to sign it here in the courtroom.
I'll be submitted at the sentencing hearing then.
I'm going to fill this out and have her sign it when I'm done. She'll need to fill in her name and address and read and sign the form, but I'm going to go over it with her briefly. Ms. Ellie, you've been convicted of a sexually oriented offense or a child victim offense as defined by the law, and you are classified as a Tier 3 sex offender. You are required to register in person with the sheriff of the county in which you establish your residency after prison within 3 days of coming into the county. You must tell the sheriff of that county where you will be living, your education, where you'll be working, and if you have a change, you must make the sheriff aware of those changes within 3 days. You are required to provide the sheriff the temporary lodging information if your absence from the county will be for 7 days or more. After the date of the initial registration, you are required to periodically verify your residence address, employment, place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change your residence, address, place of employment, or education, you shall provide written notice of the change to the sheriff with whom you recently registered and to the sheriff in any county in which you intend to reside or work or go to school at least 20 days prior to any change and no later than 3 days after a change of employment. Remember, employment includes volunteering. You are further advised, in accordance with federal law, you must report any international travel to the sheriff within 21 days prior to travel. Failure to do so can result in further criminal prosecution. You shall provide written notice within 3 days of any change in vehicle, email, internet, or telephone information that you have registered or you use, and you must report that to the sheriff where you registered. You are required to comply with all of these requirements as a Tier 3 offender in person every 90 days. It's my understanding when you come home, you will be living in Warren County. So this form will say that you are required to report to the sheriff in Hamilton County no later than 3 days upon your release. And the address will need to be added to the form for the sheriff registration in Warren County. So if you would fill that out, have her sign that, we'll make that part of the record today. A few more advisories for you, Ms. Nutley. This is a felony conviction. You are required to give a DNA sample to anyone authorized by state law. Failure to do so can result in further criminal punishment. You have the right to appeal my sentence. You have 30 days to file that appeal. If you cannot afford the documents or the costs, those will be waived. You are entitled to an attorney on appeal. If you cannot afford one, I'll appoint one for you at no cost to you. You can tell me now if you'd like me to appoint appellate counsel, or let me know within the next 30 days, or let your attorney know.
I'll speak with her about that, Judge. I'll let the court know.
Okay. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Yeah.
Ms. Nutley prepared to be taken in custody?
Yes, sir.
She needs to read and sign that form, and then you can take her into custody. Probably. You can come over. Oh, I thought you should move over here, because she's going to go faster. Or you can back up. Copy. Shows.
The judge carefully explains the post-release control period, emphasizing that it is mandatory for 5 years and that the parole board can impose additional conditions, including restrictions on travel, employment, and behavior. Any violations could result in being sent back to prison, with stricter consequences for repeated or new felony offenses. Ms. Napoli is also classified as a Tier 3 sex offender, which comes with detailed registration requirements. including notifying the sheriff of residence, employment, education, and travel changes, plus regular in-person verification every 90 days. She is required to provide a DNA sample, and she has the right to appeal within 30 days, with access to court-appointed counsel if she cannot afford one. The judge ensures all forms are signed and advises her on the procedures before taking her into custody. What do you guys think? Was the sentence fair, or should the judge have gone tougher? Drop your thoughts below, hit that like button, and subscribe for more wild courtroom stories like this. Thanks for watching, and I'll see you in the next one.